All right, good morning. We will start with the call of the docket.
2025 CD 265 in Ray of Thomas Michael Bowers.
All right,
Good morning, Your Honor. I represent Ashley Mowell.
good morning. So this is a petition for appointment of a conservator for Thomas Michael Bowers, is that correct? All right. Do you wish to put on proof that anyone who's going to testify, let's have them raise their right hand and be placed under oath?
You solemnly swear or affirm that there's nothing but the truth, so help you God.
Right, you may proceed.
Sorry. Your Honor, I have Alma Bowers, who is the mother of both Thomas Michael Bowers and Randall Nathan Bowers. May I put my proof on simultaneously
You
for
may.
both?
Let's everybody shift over in front of that microphone. Since we have someone on Zoom, we need to be able to hear.
Ms. Bowers, could you state your name for the record, please?
Alma Bowers.
And you filed this petition to appoint conservators for your sons Thomas and Randall, correct?
That's correct.
And those were filed September 15th, 2025.
Yes, sir.
To your knowledge, is everything in that petition true and correct?
Yes.
How old is Randall?
He is 55,
How old is Thomas?
53.
What kind of medical conditions does Randall suffer from?
He needs 24-hour care. He had a head injury at 17, and he's unable to talk, walk. He's in a wheelchair. We're in a hospital bed. We feed him through a tube in his stomach.
Oh, ma'am, does Randall, can you tell me what conditions Randall suffers from? Or is Thomas, I'm sorry, Thomas.
He suffers from seizures. They're uncontrolled. He takes medication, and we've tried different things like a vagal nerve stimulator, which didn't do anything. And we have done all sorts of medicines that really haven't done a whole lot for him. And he's had the front 50% of his brain divided in half to see if that would stop them. And only thing I can say about that is he could have up to 12 grand miles a day. And he stopped having that many in his, but he still has a lot per month. He's on a drug right now. They're trying him on to see if it. And of course, he's 53, and he's been having them since he was little.
Do they, either of your sons have the ability to make decisions or live independently? And they both reside in a special needs home, correct?
That's correct.
Who are their treating physicians, do you know?
Yes, Susan Osborne.
And that doctor completed a physician report, correct?
Yes.
And we filed that report with the court, correct?
Okay. I don't have the name. But she's the one that handles it. He signs off on her.
Okay. Do either Randall or Thomas have any significant personal property? And they both receive Social Security benefits, correct?
That's correct.
And you are able to ensure their money is managed correctly?
Development Services does manage the money, but
And you coordinate for their needs through the special needs home, correct?
yes,
And you ensure all of their needs are provided for, correct?
yes,
And is it your desire to be appointed a co-conservator for your sons Randall Bowers and Thomas Bowers?
yes, sir.
Is it your desire to have your have Francis Robertson and Horace Carlton, Randall and Thomas's aunt and uncle, appointed as co-conservators with you? Do you believe that this conservatorship is in Randall's best interest?
Yes, I do.
Do you believe this conservatorship is in Thomas's best interest?
Yes, I do.
Do you desire for a property management plan to be waived from your requirements from the property management plan. is-
What that means is, ma'am, the law says that if you have assets of a person that you're going to become their conservator, and let's say they have a bunch of money in the bank or they have real property, then you would have to file what's called a property management plan that would allow me to see that you have a plan to properly manage their assets. I'm understanding that both your boys only have Social Security benefits and they're in a assisted living or a supervised living, and that money, I assume, goes to pay for that?
Yes.
All right, so I'm going to waive any sort of requirement for a property management plan.
Do you desire for a bond to be waived? Have to do that.
You don't have to ask her that, I'm going to waive the bond for you anyway.
Thank you. And, Your Honor, I have Ms. Frances Robertson.
Yes.
Can you please state your name for the record, please?
Frances Robertson.
And have you heard everything that Ms. Bowers testified to as true and correct to the best of your information and belief?
Yes.
What is your relationship to Randall and Thomas?
I'm their aunt.
And do you desire to be appointed as co-conservator?
Yes.
And do you believe this appointment would be in Thomas and Randall's best interest?
Yes.
Mr. Horace Carlton?
Horace
Please.
Carlton.
And have you heard everything Ms. Bowers testified true and correct to the best of your information and belief? And what is your relationship to Randall and Thomas? Desire to be appointed as co-conservator? And do you believe this appointment is in Thomas and Randall's best interest? Your Honor, I'd like to pass up two
All right.
orders, if I could, please.
I have signed both of your orders and granted your request for conservatorship.
Thank you, Your Honor.
Good luck to you.
Thank you.
2026 CB 216 in Ray of Corey Michael Gilman.
Good morning.
Morning.
Would you raise your right hand and let's place you under oath?
Do solemnly swear or affirm.
Yes.
Good morning. Are you Corey Michael Skillman Vidlich? How do you pronounce the last part?
Vidlich.
Vidlich, all right. You have filed a petition for a name change, and I'm required by law to ask you certain questions. Are you asking to change your name to avoid criminal prosecution?
Sir.
You're asking to change your name to avoid your just debts or creditors?
Sir.
You're asking to change your name for any illegal or inappropriate purpose?
No, sir.
Then I think it's just, you want to just change and drop the Skillman part and go by Corey Michael Vidlich, is that correct?
Yes, sir.
And that's to match your Social Security Administration. All right. Then have you prepared an order that grants that name change?
Yes, sir.
We have the petition, and there should be an order that
Yes, sir.
you have prepared as well. I'm going to draw a line here on the last page of your order that for you to sign off on, just because of the fact that I need you to hand that to him, if you will, please. That way you can, we'll have proof that you were here that day and you were approving the order. All right, I have signed your order and granted your name change request. You can get a copy of this a little later in the day from the clerk's office, okay?
Thank you.
2026, 28, and Ray of Chance.
Yaros. Come up, please. You will raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the truth and whole truth.
You have, are you Chance Curry? Is it Yaros?
Jaros.
Jaros, okay. Mr. Jaros, you have filed a petition for a name change, and I'm required, as you heard me, to ask you some questions. Are you asking to change your name to avoid criminal prosecution?
Yes, sir.
Are you asking to change your name to avoid your just debts or creditors?
Yes, sir.
Are you asking to change your name for any illegal or inappropriate purpose?
Yes, sir.
It's my understanding that you want to just change your name to simply Chance Curry, is that correct?
Chance Jaros Curry.
Okay.
There should be an amended petition.
All right, an amended petition, I'm looking at the original ones.
I have a copy if needed.
No, I haven't. So what you're wanting to do is to change your name from Chance Curry Jaros to Chance Jaros Curry?
Yes, sir.
Okay. Have you prepared an order?
Yes, sir.
You will submit that to the bailiff. And again, I'm going to ask you to sign on the line I've drawn there just to show that you have approved the order. I've signed your order changing your name. You can get a copy of it a little later in the day from the clerk's office once they get the file back over there, okay?
Thank you.
2026, CB 112, Christopher Powell versus Ashley Mallett.
Ms. Collins is on Zoom, I mean, Ms. Carpenter rather is on Zoom.
Good morning, Your Honor.
We have a motion to withdraw.
Yes, Your Honor, we're going to strike that motion. I know we're set for hearing tomorrow. Does the court want my client present with the children in the morning?
I'm sorry.
I wanted to ask if the court wants my client present with the children in the morning. I think they're in Tennessee currently, the children with father.
I've been in Cheatham County for these, for the last several weeks. I'm going to look at this response that Ms. Roberts has filed, if I understand correctly.
Your Honor, if I could just kind of briefly, I filed this petition. Parties have two minor children together who lived here in Dickson County, went to school here in Dickson County. Mrs. Mao got evicted from her apartment at the Trails and packed up and left and moved out of state. She unenrolled the children in school with a couple of weeks left in school and left. We filed this petition. It was filed on April 14th. We had her served out of state on April 23rd. I set a matter for a hearing on May 18th before Judge Lockhart Mash. I believe the evening before the hearing, I received an email from Ms. Carpenter stating that she had been retained. I appeared before the court because, again, the children have left. My client went to visit with them and got the police called on him there. So when Mrs. Mal appeared before the court on the 18th of May, she was placed under oath and had to affirm on the record that she had in fact retained Ms. Carpenter and paid her in this matter. And based on that, the judge continued the hearing And we had a hearing on May 29th where Ms. Carpenter and I just reached an agreement where they were just going to do equal time during the summer. And it was set tomorrow. It is set for tomorrow because the children, again, as your honors aware, Dickson County schools start on Monday. And so it is a matter that needs to go forward, and it's set tomorrow in front of Judge Lockhart Mash, and she's heard the other matters involved in that, so.
Well, wouldn't it be more appropriate for Judge Lockhart Mash to hear the motion to withdraw?
Well, yeah.
It's going to affect her hearing tomorrow.
Well, again, and that, my position is if Ms. Carpenter has, if there's been some violation of the attorney contract by Ms. Mal, certainly don't think she should have to be an indentured servant and represent a client who hasn't paid her, or is not cooperating, whichever it is. I know ethically she doesn't have to disclose that, but she said there's been a breach of the contract. So as a result, if she wants to withdraw, certainly she has every right to do at that. But the hearing is set for tomorrow, and I implore the court not to give Ms. Mal any additional time to
Well,
file
it's not
count.
my hearing. It's in front of Judge Lockhart Mash.
And I have filed a motion for default set for tomorrow also.
Ms. Carpenter, I'm willing certainly to grant your motion to withdraw because obviously, as Ms. Roberts said, if there had been a breach of your attorney-client relationship, then, you have the right to withdraw. But I am not in a position where I can continue a hearing in front of another judge anyway. So your client will need to be here tomorrow morning with the minor children for that hearing in front of Judge Lockhart Mash.
Your Honor, I'm striking the motion to withdraw. I just wanted to find out if the court wanted my client there in person. My understanding is the children are in Tennessee with father for parenting time currently. So I'm just asking if the court wants us in person tomorrow, which is fine.
Judge Lockhart Mash does not allow appearance via Zoom.
All right, she needs to be here because Judge Lockhart Mash does not allow the Zoom appearance. So if you're striking your motion to withdraw, then the matter will remain set for tomorrow morning at 9 o'clock in front of Judge Suzanne Lockhart Mash. So,
Thank you, Your Honor.
thank you.
Thank you, Your Honor.
2023 CB 195 Matthew Phelan versus Desiree Llewellyn.
Judge, this is our motion to dismiss for failure to prosecute. I think the case.
How are you doing?
Not real good today.
Well, it doesn't look like you're doing
I think
good.
it's gonna be Monday before I'm back at it, but
Anyone who's had surgery yesterday and shows up for court today has got to have a leather strap somewhere to chew on is all I can say. So.
I had one matter I didn't feel like could be reset.
All right, this is a motion to dismiss for failure to prosecute.
Yes.
You represent the respondent mother, Desiree Llewellyn.
I do, and over the history of the case, Your Honor will note that Ms. Roberts was involved for some time, and I would hazard to guess, just like she hazarded to guess a few minutes ago, Mr. Phelan did not cooperate in communications with her. We've sent this motion to him by email. We've sent this motion to him by mail, I believe, and we're just asking that it be dismissed for failure to prosecute.
Matthew Phelan. Matthew Phelan. All right, case is dismissed for failure to prosecute.
Thanks, Judge.
Your Honor, while Ms. Doobie's up there, I have filed a motion asking I request court there.
I think that would be appropriate. This is you and Ms. Duke.
Yes, and Ms. Duke and I are involved in it.
And I didn't know if we could get a reset date on that while we're standing here.
Fine, I can try to give you one. What case is it? The Jones case?
Jones,
It's a Humphreys County case I agreed to hear here, right?
yes.
And I just handed up to you an agreed order. Ms. Duke and I were able to resolve the real property issue, and we've signed an agreed order. I may have dropped that out. That's not, I think that's one of them up there. I was going to get you to sign, and I'm going to take it back to the Humphreys County.
And this is one that we did a really short reset on this one, just so that Mickey could get in touch
Can you hand this
with.
back, please, to Ms. Roberts?
The guardian ad litem wasn't available, and we need to move it, so we don't have her here, so.
If we could get 2 dates and then us just talk to her about it, I think we should be able to
She's
work it out.
downstairs in juvenile court. Today's her juvenile court day.
I could probably give you how long do you think it's going to take?
It'll basically just be a custodial determination. Estate agreement. Back to the home for 30 days.
I gave the children the home and gave
And
your
the children
parents
the home.
visitation
We
with the
resolved
home.
that, and she's buying the home, gonna refinance it. My client's moved out, so it's an establishment of a residential schedule.
And Your Honor has heard quite a bit on this already. I think we probably won't go back behind the last order. I don't intend to. Ms. Roberts, I don't expect would, but, so maybe over the last year, you'll hear testimony about that stuff.
But thankfully, all the kids are of age that they can testify.
I will repeat my question. How long do you think it's reasonably,
3 hours.
realistically?
3 hours, I think, is a fair.
All right, well, the reason I'm asking is, I don't have any open dates for the entire month of August, but I don't really have any open dates in the entire month of September. Now, I have August the 18th, which I am scheduled for Houston County Chancery Court. And I talked to my clerk yesterday, and originally I had told her to take that day off because it needed to be, I was trying to give something to Chancery, but I could probably give you the afternoon of the 18th.
I had 2 days in August that I'm available, the 18th and the 21st. I have no other dates.
Right.
I'm in court every day other
Now-
than that, so now I only have 1 day in August.
Where will we hear that?
Where you want to go? You want to go to my hometown of Erin to hear it?
That's fine.
You
with
want me to come back here, I can do it at 1:30.
I think here would be
I
great.
think given the construction in here,
Oh, that's right, yeah.
courthouse, that might be.
They're adding on to the courthouse there.
And you have to kind of get to the elevator, ADA scenario, you have to go down steps to get to the elevator. And then get, so I would rather,
All right,
do it somewhere where,
well, I will let Ms. Brooks know that she has the morning, but that you have the afternoon, so.
What day of the week?
that's on a Tuesday.
Hopefully Mickey will be fine.
You want to
If-
double check with Mickey before
If
we,
she's not, then we'll circle back around. I have court with her this afternoon at 1 o'clock. She is, and so in juvenile, so I will check with her, and if that's not available, we'll get back to you.
now, who has the Jones file?
I talked to Miss Abby. I told them that I wasn't going to bring it because I anticipated she might be able to grant a motion to continue. So I will text Miss Abby and tell her I'm not coming to get it.
All right. Do we have anything else set tomorrow morning? There's nothing other than Jones, right? Okay,
Ms. Roberts and I have a few matters, but we're working through those, getting those reset.
But those are from Judge Dr. Mash.
Yes.
all right. Is that all you had, Ms. Duke? Call the next case.
2025 CV 255 Bruce Green versus Connie Lumpkin.
This is here on my motion to either compel Ms. Lumpkin to sign, to appear at the closing, or in the alternative, ask the court to allow me to enter an order divesting her of ownership of the property and vesting it with Mr. Green for the sole purpose of concluding the closing on the sale of the properties. This is a case, Your Honor, wherein I filed a partition suit. Previously involved, they purchased 2 vacant lots together. There has been significant amount of litigation in General Sessions Court, and then in Circuit Court on this matter. So we had to file a partition suit here. Your Honor granted the partition via default. We appeared before the court, got an order to sell the property by auction. Mr. Neil Trice effectuated the auction. It was sold, and we came before the court on March 23rd of 2026, and you approved the sale. The closing has been set. Ms. Lumpkin has failed to appear, has failed to file anything, has been served with this, is not present in the courtroom, has never appeared. And so I would request, Your Honor, I'll put on Mr. Green to verify what I have advised the court, and we would just ask for an order divesting the property with him for the sole purpose of him executing and closing the 2 contracts for sale on the property, and that all proceeds be deposited into the court after the cost of the sale, which you've already approved in the court order, and then have Ms. Lumpkin come before the court. The alternative process is for me to file a petition, a contempt petition, her to be jailed until she signs it. I do not want to do that. I think this is the most expeditious way to get this matter closed and the money paid into court.
All right, Mr. Green, raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that you tell the truth, nothing but the truth, so help you God?
You are Mr. Bruce Green, is that correct?
Yes, ma'am.
Mr. Green, during the time that you and Mrs. Lumpkin had a relationship, y'all purchased two lots out on Furnace Hollow Road, is that correct? There has been a significant amount of litigation downstairs in General Sessions Court. It got appealed, it was in circuit court. Mr. Potter represented her. We went through a number of things. We were able to resolve that, but y'all still ended up owing those two pieces of property together. Attempted to negotiate with her to get that taken care of, all failed, correct? We filed a partition suit, served her, and she failed to appear or file an answer, is that correct? And we took a default judgment and then came before the court to get permission to sell the property by auction. We retained Neil Trice to do that, and he effectuated that and sold both pieces of property by auction, is that correct? That's correct. We came before the court, presented the sales price, and this court approved the auction. Closing was set, you appeared to get everything and signed everything. You have a contract pursuant to this court order, two contracts that need to be closed out. Is that correct?
Yes, ma'am.
And you understand what I'm asking the court, what we're asking the court is for you to be vested with the property for the sole purpose of you signing the deeds to the new purchasers. Then the funds will be deposited with the clerk and master, and we'll have to come back another day to decide how it's going to be divided. And you're asking the court to do that. And again, we discussed the option of filing contempt and doing that. And again, this is the most expeditious way to fulfill your obligation under the contract that you signed.
All right, I will grant your request to authorize Mr. Green to solely be able to execute the deeds necessary to close on the sale of this property.
Thank you, Your Honor. I'll get the order over to you.
2019 CD230, Michelle Santiago versus Fernando Santiago.
That is a show cause order. I've actually, it's amazing how a show cause order can get someone's attention.
Turn that microphone just, there you go.
It's amazing how a show cause order can get someone's attention, a motion for show cause, that is. I have been in touch with them and they are working on it. The lady is out of town this week, so if we could just pass that to another date. I don't know what dates it really does not matter what date.
Doesn't matter what judge, we can give you the next, how long away do you want it?
So August the 26th.
The 26th will work just fine.
T25 CD289, Michael Thomas versus Rachel Thomas.
Your Honor.
Good morning.
Morning, Judge. We are here today. We've got a couple different motions that are on this docket. And my client should be on video.
I've admitted her, she needs to turn on it, there she is.
There she is. We've got a couple different motions on the docket today, Your Honor. I think it probably makes the most sense to deal with the motions that I've filed, which would have been for the interlocutory appeal and the motion to stay proceedings based on the fact that it's going to be filed under Trap 9 through the Court of Appeals. We came here previously and the court said at that time that should an interlocutory appeal be sought, that the court would approve that. We now are asking for that interlocutory appeal formally, which I think under the rules I have to do at that point. And additionally, we are seeking the statement that the Court of Appeals requires of the trial court in terms of what is being appealed and why the court believes that it's necessary.
What if the judge who's granting the interlocutory appeal thinks he made a well-reasoned and informed decision that the Court of Appeals would certainly uphold, but you are saying I need to draw an order that, or a statement for the appeal according to the rules. That is what is said.
Correct.
This is a case, clearly, and you want to respond to any of that? So.
Judge, I would like to respond on the motion for stay, certainly. I don't think a stay is appropriate in this case. This court's already held that it's got jurisdiction. That order is in effect currently, and that order is going to be in effect until and if the Court of Appeals overturns that order, and that's an if that happens. So I don't think a stay is appropriate in this matter. If the court is inclined to grant a stay, I think that stay should only be applicable to baby Thomas that is in Colorado. We have 2 minor children here. Scarlett Thomas is still with mother in West Virginia. The appeal is solely related to the court's exercise of jurisdiction over baby Thomas. So if the court's inclined to grant a stay, I think that stay should only be applicable to baby Thomas.
And I didn't touch on the stay. I was going to take those as 2 separate aspects of it, because I think those are 2 separate aspects at this point.
All right. It is this court's opinion that in what I stated before, this is one of the more unusual cases that I've had come before me. This is a case where, based on alleged domestic violence, which I'm understanding from Mr. Kirby, that Mr. Thomas has either pled guilty to or been found guilty of some sort of domestic violence in the past, and that led Mrs. Thomas to relocate to the state of West Virginia with the party's 1 minor child, but she was pregnant at that time, if I recall correctly, and gave birth to that child and then placed that child for adoption with a couple in Colorado, and that there is a Colorado court exercising jurisdiction over that child, or at least attempting to exercise jurisdiction over that child. Mr. Kirby's argument is that that child, that this court does not have jurisdiction over that child. I am of the opinion that this court, once I assume jurisdiction over the divorce between the parties and any minor children that the parties had, that this court has jurisdiction over any child that is born during the pendency of that divorce action. And for that reason, I am of the opinion that this court is the appropriate venue for all matters concerning the minor children. Mrs. Thomas, through Mr. Kirby, is asking for an interlocutory appeal on the issue of whether or not this court, solely on the issue of whether this court has jurisdiction over the minor child born to Mrs. Thomas and Mr. Thomas, because the DNA test results have shown he is the biological father. And if you are asking for an interlocutory appeal, you understand, if I grant the interlocutory appeal and state the reasons why, it still is up to the Court of Civil Appeal to determine whether they'll even grant that.
Correct.
So a stay as to that child would simply stay this court's exercise of jurisdiction over that child. My concern is whether or not that means that the Colorado court will continue to proceed with the adoption proceedings in the state of Colorado, because if what I don't want to do is grant your request for an interlocutory appeal and then issue a stay order on this court's exercise of jurisdiction over the newborn child that allows the Colorado court to say, hey, we've got jurisdiction because the Tennessee court has stayed that in its own appeal, and that gives them somehow a leg up. That's, I think, would be unfair to Mr. Thomas in that regard. So how do you address that? What is the status of the Colorado proceeding?
The last time, and I've been in communications with the attorney for the petitioners in Colorado at this point for the adoption, they are still going through the jurisdictional argument aspect of things in Colorado as well. The petitioners had submitted their brief on that. I believe that on behalf of father, husband, there was a petition or a brief that had just recently been submitted. There's been no ruling in terms of that in any way. My understanding is that there's not any sort of final hearing that I've been made aware of that is set on that, because they are still going through the base level of, do we have jurisdiction and what are we going to do with that? As far as the concern that the court has, it's a valid concern, obviously. I think there's 2 things I would say to that. One, we already knew that Colorado was going to do what they were going to do anyways. And this isn't giving up. This isn't
Your
giving.
time is up. Your alarm is up.
Apparently. This isn't giving up, this is not the court saying that you are giving up jurisdiction under your ruling. This is us simply saying that we need to make sure that this is happening. We are trying to be judicially efficient about it, make sure that there's a uniform body of law, do all the things that are laid out for the reasons that we go under the Trap 9 appeal in the first place. I also believe that it would be appropriate to put into an order to stay that this is, again, not giving up jurisdiction under your order, and that it is not giving free rein to Colorado to move forward, as you still believe that you have jurisdiction pending any ruling by the court.
And your argument that this court lacks jurisdiction over the newborn child has been based on the fact that the Uniform Commercial Code, the Uniform Child Custody Enforcement and Jurisdiction Act says that that child never resided in Dickson County, and for that reason, it is not this court's jurisdiction, even though I have asserted jurisdiction over the parties and asserted jurisdiction over their other child. And my response to that has always been that to follow that argument, that it would defeat this court's jurisdiction for any person like the mother to take a child, or if she's pregnant, to leave the state during the pendency of any custody action, and thereby defeat a father's right to have the court that's hearing his divorce action be able to, adjudicate the custody of all of the children, including the one that was born out of state because the mother left, which is exactly what we have.
And I think to respond to that, Your Honor, there's also a separate statute within the UCCJEA. I believe, if I remember right off the top of my head, that is Tennessee Code annotated 366223, if I'm not mistaken, but please don't hold me to that. But essentially, the statute says that jurisdiction cannot be placed somewhere else if it is done with unclean hands, essentially, that it is done with the intent of trying to go through and
Which Mr. Thomas would argue is exactly what your client has done. So.
But it's really not, because we came here before the court. She requested to go there. She requested to do those things. Everyone knew that she was pregnant at that point.
You didn't request to take the newborn child to Colorado and give it up.
That's a separate issue altogether, because my statement is that West Virginia is the home state of the child based on the child being born in West Virginia, and anything that happens in West Virginia after that, that's in West Virginia, and that's a West Virginia problem, and that's something that needs to be sorted out between Colorado and West Virginia.
So that argument, Mr. Thomas would have to then retain counsel here in Dickson County, also retain counsel in West Virginia, and also retain counsel in Colorado, which I think is not what I believe would be the effect that the law has in mind. So I will grant your interlocutory appeal request simply for the basis that this is an unusual situation, and there is the implementation of the Uniform Child Custody and Enforcement Jurisdiction Act brings before the court issues that are not normally in one of these cases, and I'm required to make a finding as to what the issues are. So my suggestion would be that I will draft the order, but I'm going to give you both 10 days to submit to me your proposed issues that you believe require an interlocutory appeal, and then I will draft, using your both suggestions, I'll draft the order that I think is appropriate for it, but I will grant the interlocutory appeal solely as to the newborn child, and I will not grant the stay of the proceedings as to the child that was born during these proceedings, or while they were living here, because I don't think that the Uniform Commercial, I don't know why I keep saying that. That was my least favorite class in law school, was the Uniform Commercial Code. It was the most.
We had a teacher that just read from the book the entire time.
Well, when I was in the University of Houston Law School, I know you really want to hear this, we had the guy who actually drafted it. He was like 110 years old, and he was from Harvard, a visiting professor at the University of Houston Law School. And all he did was sit and talk about going to lunch and what over lunch they talked about this provision. 50% of the class dropped it, including myself, dropped it because we were convinced that we weren't learning anything about the Uniform Commercial Code. I have never regretted dropping that class, nor do I ever want to know anything more about it. But the Uniform Child Custody Enforcement Jurisdiction Act, I think, is the is the key here, and that's where you need to focus what your issues are. So 10 days for each of you to submit the issues that you think need to be adjudicated by an appellate court. I will then draw the order, and if you will also submit an order granting the interlocutory appeal, then I will sign that after I've submitted, at the same time I submit my written statement of the issues.
Understood. And for the record, I previously filed already an appeal through the Court of Appeals in terms of giving notice. That one's, and I've spoken to counsel about that, it was filed under trap 3 instead of trap 9 because I, for lack of a better phrase, fat-fingered it when I was trying to put it through. It's led to the wrong thing, but we're still within there because I've got 10 days after that order is signed.
All right.
So that won't be dismissed. There will be a trap 9 put in place.
That's
after
between
that.
you and the Court of Civil Appeals.
Exactly. I just want to put it out there on record that one's going away for that purpose.
All right. If you will send those directly to my office, please, and then that would be helpful. If you want to send them to my email address, you can do that if you'd rather do it that way, whatever you want to do. Do you have that email?
I don't know that I do.
I'm going to give it to you, but I'm not going to announce it over.
You don't want to
the
put it
airwaves.
on record for the YouTube watchers?
Yeah. You two are going to have to share. I only have one.
I'll take a picture of it, Judge.
Yeah, I
That's
was going to
fine.
say, I'll take a photo of it
And
real quick.
just to be clear for the record, so the court is granting a stay with respect to any proceedings regarding baby Thomas in Colorado. We do have set today an evidentiary hearing on the father's motion to return the minor children to him.
And that's set today?
That is set today. I would ask that that go forward on the basis that the court's still exercising jurisdiction over Scarlett Thomas, the other minor child. The father has witnesses here. We're prepared to move forward on that motion. Also, the motion to reduce his spousal support obligation is set today, and we're prepared to present testimony and evidence in regard to that. His father was paying $1,500.
Well, I'm not staying the proceedings, so as to that child
And if I may, Your Honor, to give the court a little bit about the next steps there, because I don't want to have any surprises. I understand what this court is staying at this point. I may very well file through, if the appeal is accepted through their interlocutory appeal, which I believe that it will be, then I have the opportunity to also ask for a stay through there as far as both children, which we probably will. So I'd ask for time to do that because I have not been able to do it so far. I'll also point out to the court that
let me repeat what you're saying. What exactly are you telling me? That I've granted your stay as to the newborn child. Now you're saying that you may be requesting a stay as to the other child?
correct. My request.
You haven't filed anything such as that yet, right?
I've not been able to because of the fact that we need this stuff from the trial court before I can do anything through the court of appeals. There's not anything there at this time. I did request through the stay here with the trial court for it to be with all children. The reason being for that is because I believe all the evidence that we're talking about here, the purpose for doing this stay is to make sure that we're being as judicially efficient as possible for everyone. And all of the same information we're talking about is essentially going to apply to both children. I'll also say that the motion that's been filed was an ex parte that was denied. And the ex parte relief that was requested was essentially as it related to baby Thomas, that we'll say, which is part of the Colorado. There's nothing there that has any sort of issues for mistreatment or anything along those lines as far as the child that is in my client's care and custody, that she's got the order of protection that is currently there. She has the agreed order that was submitted saying that she went to an undisclosed location for reasonable fear of domestic abuse. I don't believe that any of the situations to do with what's been filed truly relates to the child that is in West Virginia at this point anyways.
Just for the record, it wasn't an ex parte motion for return of the minor children. It was just an emergency motion. Father had found out that the mother had placed the child up for adoption in Colorado. He has not had contact with Scarlett Thomas, the newborn baby Thomas, or the mother in over a year. I understand Mr. Kirby's argument that that's his own doing with respect to the order of protection. The order of protection does not, however, include the minor children. Father has gone over a year without any visitation with these minor children. In his motion for the immediate return of the minor children, he prayed for general relief. The court set this hearing to determine if the father was going to be awarded any parenting time. We're prepared to move forward on an evidentiary hearing. We're getting into a situation, the longer this goes on, the more irreparable harm it's going to create the father's relationship with these minor children.
On the flip side of that, we've got every single statute that says that because the parties cannot communicate things to an order of protection was granted and has since been appealed and is still in full force effect at this point in time as an ex parte and is not set to be heard at an evidentiary hearing, then that does not diminish father's ability to come back at a final hearing. The court is not to consider anything for temporary. So I don't think that it's going to be unfairly biased against him. And again, the statements that were there, I believe the only statement that was there as far as the child that's in West Virginia is that father didn't know if she had also put that child up for adoption, and I'm stating on record that she hasn't, and there's no intent to, and last time we were here.
So despite, let's just separate the two because you keep telling me that those two are separate issues. So let's just disregard the issue about the child in Colorado. We have a father who has not seen his child in West Virginia for over a year. And why would I not allow him to proceed with a hearing today that's been set by notice or set by court order properly? Why would he not be entitled to go forward today with a hearing regarding either an order returning the child or at least establishing some sort of visitation between him and that child? What legal principle would allow you to stop that from happening?
I think the legal principle I would rely on is the fact that, and I think the court's probably not going to agree with me for the request.
I don't think I'm going to agree with you either.
No, but the legal principle I'd be relying on is the fact that everything to do with the state about what is going to be there for, I'm going to say, judicial efficiency. Are you having to expend more time, energy, resources, financial resources?
Well, I'm going to cut you off, Mr. Kirby, because in my opinion, it is manifestly unfair to the father, Mr. Thomas, and I know nothing about him. I mean, I know what's been alleged, and I think this is a case that I set for an evidentiary hearing to determine what is the situation between these parties, what has happened in the past, what are the conditions, like any other child custody case. And I'm going forward with it today. Now, I will pass this case to allow you two to talk about it, but we're going to come up with some sort of a way for Mr. Thomas to have some sort of contact with these children, with this child. It's just a question of under what circumstances, what safeguards and so forth that are going to have to be done. But I have some other matters that hopefully will not take as long, and I expect that we'll have to have a hearing. It'll take some time for your case. So we're going to pass you on the docket and come back to you in a little bit. Your client's on the Zoom. She can stay, and I'll just put her back in the waiting room, and you can talk to her and be prepared for that hearing.
Understood.
Thank you,
And we'll
Judge.
talk in the meantime.
All right.
Thank you.
Thank you. All right, call the patent.
Good morning, Your Honor.
Good morning. Mr. Patton, it's my understanding that you have declared bankruptcy, that some notice has been given. Is that correct?
That's correct, Your Honor.
And that basic of your bankruptcy, you've included the real property that I made a ruling on in this case?
Correct, Your Honor.
Based on the bankruptcy laws, and I'm foreclosed from doing anything regarding the real property that's included in your bankruptcy action.
Your Honor has already ruled that that real property is Miss Patton's.
Agreed.
So, and he is holding a necessary insurance check that Your Honor has already said was awarded to her. This divorce has been completed for some time. Real property was awarded sometime. He's tried to backdoor it by filing a lien in the Register of Deeds office. This real property is fraudulently being placed into the bankruptcy court, and it should
That's
not
for the
be.
bankruptcy court. I agree with you. I agree with everything you said. He has no basis to include this real property in a bankruptcy action. But a bankruptcy court is the sole judge, the sole area that allows for the for the determination of whether the asset that is alleged to do that. So Mr. Patton is treading in very thin ice with the bankruptcy court, because likely the bankruptcy court is going to find, as I have ruled, that he doesn't own an interest in that property. And as a result of that, he has attempted to defraud the bankruptcy court, in my opinion. And I think that the bankruptcy court will need to have an opportunity to determine that, because there's an automatic stay on any proceeding involving property that's alleged to have been included in a bankruptcy action until that bankruptcy court does that. But it doesn't stay this court from finding Mr. Patton in contempt of this court for failing to abide by this court's orders. You have not filed a motion for contempt, but I expect that's what you will do next.
That is what I will do next. We found out this notice was shoved into the door at my office in the middle of the night last night. So we've just found out about it this morning.
The notice of what?
The notice of bankruptcy. So that being said, I did want the court to know about the lien. He is still holding that check hostage. And he has filed some motion to have me disqualified as counsel because his girlfriend has some sort of relationship with Hidden Valley Properties, which our office represents, which is.
Let's hear that motion first.
Okay.
I'll allow him to argue that motion. You filed a motion to disqualify Reynolds, Potter, and Reagan in Vandervoort. You drafted this personally, did you, Mr. Powell?
Yes, I did, Your Honor.
Okay.
So at this time, Your Honor, I am preserving my motion to disqualify under Tennessee Supreme Court Rule 8, RPC 1.7, 1.9, 1.10, based on overlapping representation and confidential information concerns.
All right, I'm here. Anything you want to say?
I mean, I would like to preserve that for a future.
Reserve what?
The motion to just.
Now, we're going to go forward with the motion for disqualification
disqualify.
today. So you can argue it, and I'll rule on it. Tell me why you think that this relationship that you set forth with Mr. Vandervoort, being the attorney of record for a realist from some sort of Hidden Valley Lakes or whatever.
Okay. Your Honor, regarding my motion to disqualify, there's a severe conflict of interest that breaches attorney-client confidentiality. Ms. Duke's firm represents Hidden Valley Lakes and its president. I volunteered there, and highly sensitive and private details regarding my active divorce were directly shared by this firm, or with this firm, by the president and Mr. Vandervoort. Opposing counsel has access to confidential information that can be obtained through that representation, and that creates prejudice against me with regard to the divorce matters. That completely undermine the integrity of these proceedings.
All right, I've considered your motion to disqualify, and I've reviewed your basis for that, and I find that there is no basis for disqualification of Reynolds, Potter, or Reagan, that the basis that you have set forth would have no effect upon this proceeding, nor would it have anything to do with Ms. Duke's representation of Ms. Patton. Was there any other motion that needs to be dealt with today? Ms. Duke, I want you to draft an order that this court finds, as I have previously found, that this court has previously ordered Mr. Patton to execute the deed to this property as was ordered originally in the divorce decree, that he has been. The notice of lingua pendis. So that would be a situation where this court would have to deal with that, but I think the bankruptcy court's going to have to deal with that. But I will stand by the order that the court has made regarding the check that was from the insurance company, because I believe that was part of my earlier ruling, that he has 5 days to execute that check. And if he fails to do so, I will hold him in contempt. Mr. Patton, I think you're playing games with the legal system. I think you are attempting to try to divert or to avoid this court's rulings previously. I don't think you have any basis to include that real property in the bankruptcy action that you filed. You are getting some bad advice, and I'm telling you right now that that bad advice from whoever it's coming from, whether it's your girlfriend or some other person, whoever's giving you advice on how you can subvert and get around this court's rulings regarding this case is giving you bad advice. It's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders. But I'm not going to tolerate you playing games. And I don't think the bankruptcy court's going to do that either. And so you might get prepared, because I think the bankruptcy court, when Ms. Patton hires a lawyer and they proceed in the bankruptcy court, they're going to take a dim view of you attempting to use that process. Anyway, that's the order of the court. You may step aside. You may.
So, Your Honor, I had 2 other things that I'd like to discuss if possibly.
What are those?
So I would like to be on the record. I'd like to preserve that the deed was recorded before the written order was entered under Tennessee Rule of Procedure 58. A judgment is effective only when written and entered. And third, the deed acknowledgement is defective because I was never personally before a notary. And then, like I said, I asked that the property issues be continued. As far as the check, I have no knowledge of where that check is or where it's supposed to be. Ms. Duke told the court that it was at her office, and I agreed to go sign that check at the office. She later told me that it had been mailed to somebody or somewhere. And at that point in time, I have no knowledge or receipt of this check, Your Honor. So it's not a matter of trying to get around not signing it or avoiding it or anything like that. I have no knowledge of where this check is, and I've not been requested by Ms. Duke to come to her office and sign for this check.
Judge, we have confirmation and tracking that it was dropped off at Mr. Patton's home. And I can't control where the insurance company sends a check. I represented to the court that as they had told us, they were going to send it to my office. They did not. We've got tracking to show that it was sent to his house. He knows he has it, and he's refusing to provide.
Once again, Your Honor, I do not have the check. Never received it. If it was mailed to the house, it's not at the house. So,
Ms. Duke, this court will order the insurance company to issue that check in your client's name only and to issue it directly to your office. And by order of this court, I'm directing the insurance company to issue the check solely to Mrs. Patton, and because she is the true owner of the property, and it's to be issued and mailed to your office, sua sponte. Secondly, your request regarding, or your objection regarding the deed execution is overruled and denied.
Understood, Your Honor.
And I will point out, the original order trumps everything.
This court ordered it from the bench, And it's just like any other order in this court. If it's not in, even though it may not have been a written order at that point, you were ordered to do certain things and you did them. So it doesn't matter if you signed the deed because I ordered you to do so, then later saying, well, that order hadn't been, the written order hadn't been entered is an attempt to, again, subvert and get around what this court says. Why would you object to the order being, why do you even object? Tell me why that is.
Because I've filed a motion 60.02 to contest this whole process, Your Honor. So it's been under contest since I filed my motion 60.02. And then Your Honor ordered me to sign a quitclaim deed over on the 10th, or excuse me, the 15th.
Well, I'm overruling your objection to the deed because of the fact that this court is of the opinion that you did so in compliance with the court's order. Your Rule 60 motion will have to be heard after the bankruptcy court deals with you.
Well, and it was in compliance with the final decree, so it even goes back that far.
There is nothing in the decree that states that I am to sign a quitclaim deed, Your Honor, and give up my rights to a $150,000 debt. It's attached to a $150,000 debt.
All right, I've made my rulings.
Understood.
Thank you, Judge. I'll submit an order.
Three CV 77, Claiborne versus
Good morning, Ron.
Good morning.
Mr. Guerin stepped out. I was sitting on the side of that.
I'm sorry.
I believe Mr. Guerin stepped out. It's his motions.
All right, well, we'll take a short recess and let him come back in, and once we do that, we'll deal you first, and then we're going to go back to the Thomas case.
Thank you, Judge.
All right, we'll stand in a short recess.
All right. This court is back in session. You may be seated.
All right, we are ready then on the Claiborne versus Claiborne, Childress Claiborne. All right, we have her up here. It's unmuted. You're good. All right, this is a motion to alter or amend. Mr. Guerin, that's your motion. You may argue it.
That I filed on July 6th of this year. I'm not asking to relitigate the divorce, relitigate the contempt. I'm asking for very straightforward and narrow relief. I'm just asking the court to modify Ms. Childridge's.
All right, the rule has been requested. Anyone who's going to be a witness needs to step outside of the courtroom and remain outside of the courtroom until you or yourself are called to testify. You're not to discuss the testimony of any other witness with anyone until you yourself have testified. Now you may proceed.
Thank you, Your Honor. And actually, as it relates to the witnesses, after speaking to Mr. Hawley, the witnesses may not be necessary. I subpoenaed 2 officers to testify that Mr. Claiborne received some of his property back from the police department. I don't think Mr. Hawley is going to dispute that. I believe Mr. Hawley was actually present for that. If we can get a stipulation of that, I can release the officers. The people he subpoenaed, I don't think that anything they'd have to say is relevant to my motion, so I don't think they're necessary either. Most of this is just legal and procedural issues. At the time that this court, back on October 31st, 2023, this court ordered by default divorce in favor of Mr. Claiborne and also granted the motion for contempt. And that's what I'm asking the court to alter, amend is the order as it relates to the contempt. Ms. Childers was ordered to pay the sum of $42,506.07 or serve 180 days in the Dickson County Sheriff's Office or Sheriff's Department. But at the October 31st hearing, Your Honor ruled from the bench, but the final order that Your Honor entered was, at least according to the certificate of service, wasn't sent out until June 4th of 2024. And then Your Honor entered it, I believe, on June 18th, which is well past the 20-day local rule for submitting the order. I've reviewed the file, and if I don't think I'm mistaken, but maybe I am, I did not see any other court dates between that October 31st, 2023 hearing date and the date that Your Honor entered the order. At least based upon my review of the file, I didn't see any motions filed or any pleadings or anything occurring.
My recollection is there were no other court dates, that Mr. Hawley had submitted an order that I didn't agree with the wording of it, and I declined to sign that order and instructed him to redraft the order with what I thought was the appropriate language, and that took some time to do, but that's why it was not. There were no court hearings in between. It was just a matter of me reading the order, disapproving the language that was used in the order, and then asking them to redraft it with the order that I thought was appropriate.
Okay. Well, that order does have a certificate of service on there, and those addresses and email address were not good contact info for Ms. Childers, so she never received the order, despite a few times after the hearing date she called up here, called the clerk's office to get a copy of the order, and she was told every time that you just have to wait on the order to be filed. She only learned of the order after being served with the capias some almost 2 years later. We're now about 3 years out from where the order was filed. And all these items that are listed in the order for her to return, some of the stuff Mr. Claiborne has been reunited with. There's really nothing in the record to suggest that Ms. Childers still has these items. There's nothing to suggest that she has this $42,000. I understand this is civil contempt, but she has to have the ability to purge herself of this, and there's nothing to show that 3 years later that she currently has the ability to purge herself of this contempt. So basically what we're looking at now is basically a debtor's prison. She doesn't have the ability to purge herself, which there's nothing to show that 3 years later she now does. It's become punitive. And because of that, Your Honor, I would ask that the court alter its order or just enter a new order to release her, to show that she's, she's been in jail, 4 months now? The appropriate remedy for Ms. Childress would be to release her from custody. So I'd ask that you grant our motion, modify her sentence to 10 days, and to release her time served from the Dickson County Jail.
Ali, you wish to make an opening statement?
So I remember that we did have some court dates kind of after that October date, Judge. I had put together, and I've given a copy of it to Mr. Guerin. This really is nothing.
You may be correct. This had been, that order was from a hearing in 2024. And as a result, I'm not sure that my memory of it would be as clear.
I've shared this with Mr. Guerin. We talked yesterday, and then I gave him a full copy of my timeline today that's got everything attached to it. I tried to streamline this because this file is rather voluminous and different orders and things flying around. But this is all the orders, the motions, the things that I felt like were important to and germane to our issues here today. You look at the timeline, there was a February 15th, 2024 court hearing, and what all led up to that a little bit. And then there's also a June the 4th hearing on the motion to approve the order. And we did have those other two court dates. I had lodged an order with the court. And again, the court had some issues with the order, wanted some amendments. And we had that February 15th hearing, which I sent notice to Ms. Childress at the two physical addresses and her email that I had. And we had that hearing, and the court instructed me on what to do on the 15th of February. And then there was another change on the 4th of June at our hearing there. And then I submitted an order that the court signed on June the 18th. So this court took special care with this order. The first order I sent in, I mean, I did it like I do the civil contempts and whatnot, jailed indefinitely. And the court said, no, you didn't want that. You wanted a provision in there for her to have 6 months of incarceration and to be let out after that. So she was not jailed indefinitely. And there's some other things in there too that this court did that, again, taking careful consideration with the order that you did. Our position today, Judge, is really one of a few things. One, I've filed a response in opposition. If we're going to oppose this, obviously, I think the court, I can get into the argument on that if the court wants, but I think the court took great care with this order. I don't think there's anything that's inappropriate with this order. If the court will remember, it was a fairly egregious situation where she had gotten a domestic assault on Mr. Claiborne, got control of the house, and basically ransacked the house. There were, and the court heard hours of testimony about defecation in drawers of Mr. Claiborne's clothes, urination on the furniture and the beds and things of that nature. There was a lot going on at that time. And Judge, basically, we are asking that, number one, if we're going to go forward with the motion to alter or amend, that be denied. I think the court did what the court was supposed to do with that. Number two, let her out of jail with some stipulations. We're fine with that. You know, she's here today basically wanting to get out of jail. That's what this motion is about. What we're about today, Mr. Claiborne just wants what's due him, what his justice is out of this order that the court did. Either his stuff back or the money paid, and we've already beat that horse all the way around the track, and there's an order now for that. But we say she's, got some time left on her 6 months. Let's stay that, or however the court wants to do it. This is contempt, and the court has the absolute reins, in your hand to do what you want to do here. You're driving this bus. Let her out of jail. Let's reset this maybe to the 1st of December. Give her a little bit of time to either make some payments, get this stuff back. Let her know that this is a serious matter. I don't know if she understood it was this serious, but let her know it is a serious matter. And let's come back in December and see what she's done and it's up to the court then to do what the court wants to do, to see what her conduct was during this period of time. We're not getting any satisfaction here seeing her in jail. You know, Mr. Claiborne wants the return of the property or his money back. And at that time, there was a present sensibility for her to be able to return this property. The court found that. It's in my response. And I'll be glad to go over the response and argue this in detail if we need to. But at this time, we're fine with letting her out. But put a few stipulations on it that we've got a reset date. I may want to file some interrogatories about her. We think maybe she's gotten a settlement, some things like that. We want some sworn answers about that, and either continue this motion to alter, amend until then, or do whatever the court wants to do. But we're fine with that as well. That's, I think, probably the preferred remedy for Mr. Claiborne, to be honest with you. So one of those two is what we're requesting. And again, I'm a little in the dark here as to what we're doing. If we're arguing only the legalities of this, I'd like some more time. If you know, we're calling witnesses, obviously that's up to Mr. Garrett, it's his motion. But if we're calling witnesses, you know, I may call some witnesses, especially Mr. Claiborne, to contradict some of the things. But by and large, if we're going to argue this legally, I'd like to have opportunity basically to argue it legally. But those are, as far as my opening statement goes, that's what it is. Thank you,
Well,
Judge.
this court considers this situation to be similar, if not exactly like a father who has not paid his child support and has accrued a large arrearage of child support under a court order and then fails to comply with that, then there is a remedy that's given to the court, and that remedy is for civil contempt. The first order that Mr. Hawley, I think, drafted, if my memory serves me, included language that she would either return all of these items or pay him the amount, or she would be incarcerated indefinitely. And I think that was the part that I objected to, because under the law, I can only punish someone by giving them jail for 6 months at a time for civil contempt, but I can do that twice a year, as has been pointed out in child custody cases. But even in the most egregious child custody cases, what happens is you give someone an opportunity to see what it's like to be in jail so that you can hopefully motivate them to come in compliance with the court order. Civil contempt versus criminal contempt. Mr. Guerin makes the argument that this case has transitioned from civil contempt to punitive and therefore criminal contempt, and that's his argument that she's could only be punished by 10 days in jail for criminal contempt. But this court disagrees with that, because under the circumstances, this court heard this case over many, many different court dates, and there was an egregious set of facts in this case. There was a short-term marriage, and sometime shortly after they had married, Mrs. Claiborne got an order of protection against Mr. Claiborne and dispossessed him of his own house, the house that he owned prior to their marriage. The evidence at the trial was that the house, when he left it, had numerous items of personal property that belonged to him and his late wife, and that during the course of the time that he was out of the house, that Mrs. Claiborne had visitors, a number of visitors and parties and things at the house, that the next door neighbor testified that, and took pictures of parties at the hot tub behind the house and different things that were going on like that. So when I ordered her to vacate the house, because it was his home, on a temporary hearing, then she vacated the house. But the testimony was that numerous items, a great number of items were removed or damaged, and that, in fact, what was more convincing to the court than some other things was the fact that there was testimony that the drawers of the dresser in the bedroom had been removed and feces had been smeared on the bottom of those drawers. That indicated to me a malfeasance on the part of Mrs. Claiborne or someone acting on her behalf that justified a finding that she should be required to make Mr. Claiborne whole. The fact is, in most divorce cases of very short marriage, the idea of the court is to hold that parties would be restored to the same position they were in prior to the marriage. Mr. Claiborne owned that house before. He owned all of those properties beforehand, and all of those personal properties beforehand, and that they were missing at the time. We had an extensive hearing where we went through all of the list of items that Mr. Claiborne had that he testified were missing. And the court found that it was justified to hold that she was responsible for their removal while she had possession. It's kind of like what we studied in law school, you know, when you were in possession of someone else's property, you're kind of in bailment of it. And when it goes missing with her situation, it obviously she had a number of people there in the house. Some of those were, you know, not particularly reputable characters. And in fact, I think one of her friends testified against her at the final hearing in this case anyway. So I found that she was responsible for the loss of all of those items of property, and that Mr. Claiborne was entitled to the return of those items, and that she had them or she had destroyed them. And if she had them, she could return them. If she destroyed them, she was liable for the value. I had a hearing. I made a finding as to the valuation of that property, and I ruled that she was responsible for it and that she should make those payments. And she failed to do that, and that's where the order for contempt came in. And I found that she was in willful and deliberate contempt because those items had been removed or damaged. She knew, you know, either where they were or she was responsible for them. And as a result of that, I think it was just that I entered that order. That is no different than if a father or a husband had dissipated assets. Let's say instead of personal property in the home, there was a $50,000 checking account, and one of the spouses had surreptitiously removed that $50,000 checking account. They would be held responsible for that money. And that's the same thing I did in this case. As a result of that, I'm of the opinion that the motion to alter amend that Mr. Guerin has filed, and I've considered it, and his argument that it should be converted to a criminal contempt and 10 days in jail is denied, because I think that I was correct in my ruling initially. But as I have pointed out, you know, even in a case where a father owes substantial amounts of child support, after a period of incarceration, it is usual for the court to give that person an opportunity to be released by suspending the balance of the sentence and then allowing them to be back out on the street, so to speak, trying to find a job and trying to find a way to pay this. This court is of the opinion I was correct in the amount that I set or the items that would be returned. If items have been returned to Mr. Claiborne that since the entry of that order, then those items, the valuation was set forth in the order that was found, and those items, the value of those items would be deducted from the amount that she owes, just like a payment had been made on child support. The remaining balance would be her responsibility. And therefore, I find that the appropriate and equitable matter in this matter is not to amend or alter the order, but rather to suspend the balance of her sentence for civil contempt at this time, allow her to be released with the condition that we set a review. I think I'm back here in September, and then again in, when am I back? January? We'll set it for review in January to determine whether or not she has made any progress in retiring. And I'll be honest with you, if she's making payments towards that satisfaction of that debt, then just like a father in a child support case, I will give her an opportunity to continue doing that. The January the 5th, how about let's make it January the 26th. That'll give her a full period of time. January 26th, we'll set a review date on this case. In the meantime, she is released with the understanding she is going to make progress towards satisfaction of the debt, and then we'll take a look at it at that point in time. Yes.
So one of the issues was her not receiving notice. That was in the motion.
One of the issues was what?
Her not receiving notice of some of this stuff at the end, and I did what I was supposed to do. I did the certificate of service to her 2 physical addresses I had and her email. Can we put in the order that she's required to let the clerk know what her current address would be?
It is the
for mailing
responsibility of all pro se litigants, or if you have an attorney, that she must keep in touch with the clerk's office and give us a valid address. So Mr. Guerin, I will put in the order that your client must provide Mr. Holly with her current address. That's fine, as long as the fact is that she's being released, but on a specific review date, then I want to know where she's living, because if she doesn't comply with the court's order, if she just vamooses, then we're gonna have to issue a warrant for her. And I'm not gonna arrest you. I'm gonna send it for her.
Yes, sir.
So I
I just
think
need
the
address.
best thing to do is to just require that she provide you with her current mailing address. Now, when she has that address, the order will provide that Mr. Claiborne is to have no contact with her. In other words, if he doesn't contact her by mail, by phone, or any other means, and she should not contact him. Let's just separate them. They don't need to be together, and I'm making that a ruling. But I do think her address being a part of the court record when she's released is no different than, again, I'm treating this like a father who's been behind in child support, so.
I should make sure I'm doing the right thing and sending it to the right spot. If Mr. Guerin wants to be responsible, I'll be more than happy to send it to him. And just to announce to the court, I may want to file some brief interrogatories about, basically her ability to pay. We think she may have a judgment. There's some other things. So I may want to ask a couple of questions about the receipt of the monies for that judgment. And if we've got items that he's received, I will get with him. I will get with Mr. Guerin. We will attempt to work that out. If we can't, can we reserve that for the review date in January?
That's fine. I think it was Exhibit A that was the listing of the items that you had.
It is, and it's in my timeline. I put that June 18th order in that timeline, and I gave a copy of it to Mr. Guerin today, so if he'll look, you should have Exhibit A in there for his records. Yes. There's a June 18th order in there, and it should have that Exhibit A
I wanted Mr.
attached.
Guerin to be aware of the total amount of the judgment that was entered against her, so that's why. I'm sorry, how much? Okay. 42,000 and some odd dollars, all right. And whatever the value is of the property and all of that valuation is set forth on that Exhibit A, so deduct from that balance what is owed and
Yes, sir.
what the value of that property would be, and we'll go from there.
That's well understood, Judge. We'll do that. And then again, if there's any dispute, we can, if it pleases the court, I put that to order. We'll just reset that for January.
All right,
Can we reserve attorney's fees and have that at our review date as well?
certainly. Well, we need to have an order signed that would allow it and set it for review. You all can draft even just a simple order that she's to be discharged subject to a review and then supplement that with a more complete order. Then that would be the best way to handle it. If you can do it today, I'll sign it today. I saw Lieutenant Martin or Captain Martin or whatever he is, one of your witnesses. You want to bring him in here, we'll tell him what I'm doing, so in case that makes a difference for the jail. I have completely destroyed your files. I don't even know how I did that. All right. Excuse me for blowing my nose. I took it apart, probably. I am ruling that we're going to let Miss Claiborne, I'm going to discharge her from jail today and subject to a review, and there will be an order. It'll take a little bit for them to get a typewritten order, but she's going to be discharged on the civil contempt and be brought back in January for me to review what she's done. So I just want to let you all know so that even if she needs to get out of there, then y'all can let her out by my order to you today, because even if the written order takes a little bit.
sir.
All right,
Got it.
thank you. Y'all are free to go, by the way. You want to let your other witnesses know they're discharged? All right, that'll conclude this hearing.
Thank you, sir.
Now we're back on the Thomas versus Thomas. Yes. You talking about the order? Give it to the clerk's office and then put it in my file. I'm here usually every other day or something like that. All right. Are we ready? We are, Judge. All right. This is your motion, I believe that your petition for immediate return of the minor child.
That is correct, Judge. There was also a motion set today to reduce spousal support. I would call,
Mr. Thomas, I'm going to ask you to come around, turn that camera on again. It keeps going off. Where's that camera there? Let's see, where do we have we got to have a microphone set up somewhere. Let's have him go over here. I need that to stay on so that I can, yeah, hit the camera. There you go. Say if you will, Mr. Thomas, raise your right hand. Let's place you under oath.
grab a seat, Mr. Thomas. Mr. Thomas, would you please state your full name and address for the record?
Michael Jarrell Thomas Jr., 1790 Cedar Creek Road, Van Laird, Tennessee.
And how long have you lived at that address?
About 4 years.
Okay, and do you own or rent that residence?
I own that residence.
Okay, and can you describe for the court the residence? How many bedrooms, bathrooms?
Sure, yes, sir. It's 17-acre farm with,
Pull that microphone up there to you. Ms. Thomas is on Zoom, and so it's important that she be able to hear everything.
it's a farmland with a 25, I think it's 2,500 square feet
If you don't mind just sitting there and keeping it on, so.
log cabin. And so it has 6 bedrooms. Yeah, 6 bedrooms, 2 baths, a basement, a loft in the cabin.
Okay, and is that where you lived with Miss Thomas during the marriage?
Yes, sir, it is.
Okay, does anybody live there presently other than you?
No, sir.
Okay, so you live at that address alone?
I do.
Okay, and do you have rooms set up for the children?
Yes, sir, I do.
Okay, and do you have rooms for both children, both Scarlett and baby Thomas, or just one
Yes,
of
sir,
the
I
children?
do.
Judge, permission to pass
You may.
this to, so I've already given these copies to opposing counsel, Your Honor. Mr. Thomas, I'm gonna hand you pictures.
Yes, sir. This is bedroom number 1 that has been set up specifically for Scarlett. And you know, I've not been given the name of baby Thomas. We're referencing her. You know, so this room was set up for these girls, and this is bedroom number 1.
Okay, and do you have clothes? Does it depict in those pictures clothing for the minor children?
Yes, sir. There is some clothing there. There are toys there for the girls, and yes, sir.
Okay, so if the court were to return the children to you, you've got everything set up that you need to take care of the children, is that correct?
Yes, sir, that's
Okay.
correct.
And Judge, I'd move to make that. Did you take those pictures?
I did, yes,
And
sir.
is the condition of the residence in the same condition as it was in those pictures that you took?
The exact precise position that these pictures show, yes, sir.
Judge, I'd move to make those
All right,
collective
if you'll
exhibits.
pass that to the clerk so that she can mark it as an exhibit, please.
No objection for the record.
Guess I should have asked you first. So.
And Mr. Thomas, just to get through some more background information before we kind of get into everything, where are you currently employed?
Currently, I'm employed at Clarksville Granite Company.
Okay, are you the owner of Clarksville Granite Company?
I am the owner, yes, sir.
Okay, and that is an S corporation, is that correct?
It is, yes,
Okay.
sir.
But you are also employed by them, but you are the business owner.
I'm going, for the record, I'm going to show these photographs to Ms. Thomas so that she's able to see what's been marked as Exhibit 1 since she's appearing by Zoom.
Sir.
Sorry. All right, thank you. You may proceed.
And Mr. Thomas, how long have you owned Clarksville Granite Company?
October 1st, 2018. That would put us at 8 years, a little over 8 years now.
Okay, and what do you typically do? What does a day-to-day look like there?
Day-to-day for me looks like I handle pretty much everything at that business. These days I wear most every hat there. We sell granite countertops. We install granite countertops. We manufacture and fabricate granite countertops.
And do you have employees there that work for you?
I did have many employees when I was married. Well, I'm still married, but when Rachel and I were together, I had about 5 to 6 employees and 3 subcontract installers. Yes, sir.
Okay, and so do those employees no longer work for you?
They no longer work for me.
Can you tell the court what happened?
Sure. So after the protection order was put into place, I had never suspected. I was caught off guard, so I went back and I started looking in all of my media devices that I owned to find out why my wife was making these false allegations against me. And as I looked through all of these devices, I found messages from many different men. I found pictures in my game cameras all over my farm where men were coming into my house. They were driving into my home. So that's what I found and some of those men worked for me, and many of my employee base, pretty much my entire employee base, was having some type of relations with my wife. And so when I found that out, I lost all of my employees. 2 of those were my sons.
And so you've had a significant reduction in your workforce there at Clarksville Granite, is that correct?
Yes, sir, I did.
Even though that significant reduction has occurred, do you still maintain flexibility with your work schedule?
Yes, sir. Okay. So that we've been able to keep the doors open. I did lose my entire cabinetry division as a result of my wife's actions. So that entire crew I had to let go because of what was going on there. I have one gentleman that works for me now, and he is my subcontract installer, and he also helps me fabricate granite countertops.
So if the court were to return eventually the kids to you, would you be able to facilitate childcare while you're at work? Would you be able to facilitate daycare and things of that nature?
Yes, sir. I have made those arrangements.
And are there specific individuals in mind? Is there someone here today that would be willing to help you with the children?
Yes, sir. There are people here today.
And so kind of getting into a little bit of the backstory, when did you and Rachel marry?
We got married on April the 13th of 2024.
Okay. And what led to the separation?
The separation, I had no idea we were separating. What led to it, it came out of nowhere to me, to be honest. It was one day we were married, and the next day she was gone and making false allegations about me. I was totally blindsided by this.
Okay. And was there a specific point in time when that happened? Did she go out of town for a period of time?
Yes, sir.
Okay. And what happened when she came back?
Sure. So first, Rachel asked me to buy her a ring to recommemorate our marriage. This was 7 days, no, maybe 2 weeks before she made false allegations against me. She asked me to give her $7,000, 5 or 7, to buy a wedding band that she wanted to recommemorate our wedding. And I gladly gave it to her. I was in love with her, you know. I gave her the money, and supposedly she bought the wedding band, and she said she wanted to go to my sister's wedding for a period of about a week, and also some type of girls thing they were doing for about a week, and she left her children, her 13-year-old and 15-year-old teenage child with me, while she went to Atlanta, Georgia, spent 1 week, and during that week, we had some telephone disagreements, and she had mentioned that she was pregnant at the time, and that she wanted to have put the baby up for adoption. And part of the argument that we had while she was there was that I did not agree to the adoption. I in fact expressed to her that I would prefer to divorce her than to adopt our child out. She did not want the child. She felt like her hands were full, and she did not want to take the responsibility of that baby. And so I several times on the phone, I probably have messages, I conveyed to her that I would prefer to divorce her than have an abortion. So the night that she returned from this Atlanta trip is the night that she hit the record button on her phone, sat down, started an argument with me. The next day I woke up, and the cops were there telling me I had to leave my home, and that she had made false allegations against me.
And so can you explain to the court what your relationship was? How old is Scarlett, first of all?
Right now, Scarlett's 14, 15 months old.
Okay.
And,
And then how long has it been since you've seen Scarlett?
not seen Scarlett for last September.
This past September?
Yes,
okay.
sir.
And what was your relationship like with Scarlett prior to Miss Thomas leaving?
It was a beautiful relationship that she had become my whole drive in life. I was presented with this little angel every morning when I woke up. I would spend about an hour and a half with her before I went to work while Rachel prepared for her days. I would take the baby and take care of her during that time before I left for work. When I got home from work, Scarlett was given to me because Rachel had had a long day, you know, taking care of her. By the time I had gotten home from work, every day without hesitation, she was thrust upon me, take the baby, you know, and I would rush home from work to take that baby. I was in love with that baby. I still am, but I've had to push it all in the back and not think about it because it hurts so much so that was our relationship. Like I took total care of the baby while I was at the house.
Did you provide for her? Did you provide food, clothing?
Yes, sir.
Medical care? Did you ever take her to the doctor?
As far as the doctor, I think we did go to a doctor visit one time. Yes, sir.
And she had a primary care physician when she was here?
She did. We had set her up with one of my pastor friends who is a physician's assistant and has a practice in Clarksville. His name is Cliff Signer.
And so you had mentioned a moment ago about the adoption and being made aware of the adoption. Did you take Miss Thomas seriously when she had mentioned sending this newborn child or setting this newborn child up for adoption?
I didn't really think it was that serious, no, especially when I told her that I would divorce you. That was my way of saying we're not doing this.
Did you ever tell her if she signed divorce paperwork, you would sign adoption paperwork?
I may have said those words in a message to say to her, if this happens, we're getting divorced. You know, the only way this is happening is if we get divorced.
Did she ever consult any adoption agencies that you're aware of?
So I'm not aware that she consulted any
Were you
adoption
ever a party to
agencies.
any of those conversations? Did you ever consult with any adoption agencies?
Absolutely not.
Okay.
This whole adoption was, I did see in an email where she was reaching out and social groups on Facebook where she was soliciting Facebook groups to find a person to adopt this child. You know, and I think I sent you those emails where she had, you know, this was after the divorce was filed. You know, we were no contact. But
So after that order of protection had been entered, after the divorce had been filed, you had no contact with her about the adoption?
That's correct, sir.
Okay. She didn't tell you she was about to place the child up for adoption? She didn't tell you that she was signing a termination of her parental rights?
I had no idea any of those things were happening. I was in the dark as to.
And you only
any
found out that it
information.
occurred after you'd been served with that
Yes,
petition,
sir.
is that correct?
I had suspected, you know, that she was considering that, but I had no idea.
And so it's been represented to the court that you have been convicted of domestic assault. Now, let's go back. You had described earlier an incident in September. Is that the incident you're referring to?
Yes, sir.
Okay. And what plea did you enter? Do you recall?
I don't recall the name of the plea, but I do recall that the attorney advised me that when after the judge read the plea off and I agreed to it, that to be sure that I say not guilty within that I'm not guilty of this. I don't remember the name of it, but it was when the judge said, "How do you plea?" It was very clear that my attorney made it to me to say the word, "You plead not guilty."
If the court records reflect you entered into a no contest plea to a simple assault and a violation of an order of protection, does that sound accurate?
Yes, sir.
Okay. And you were, as a result of that, you were placed on probation for a year, is that correct?
Yes, sir.
And are you currently still on probation?
Yes, sir.
Have you had any issues with probation?
No, sir. I
Have you
have
failed
not.
to report to probation?
No, sir. I
Have you had
not.
any probation violations filed against you?
No, sir. I
Have you
not.
failed any drug screens administered by probation?
No, sir. I have not.
Have you paid your probation fees and court costs?
Yes, sir. I have.
And so as we sit here today, there are no violations of your probation, correct?
That is correct.
Have you been charged with any new criminal offenses?
No, sir.
And why did you enter into a no contest plea instead of going to trial?
Well, number one, I was not guilty of the charges, and my attorney advised me that was the best thing I could do.
What do you want the court to understand about how you've responded to everything that's happened over the last year in your life?
Wow. I'd like the court to know that on September the 21st, my entire world was taken away from me based on a false allegation. My entire world was destroyed. I was in love with my family. I was not a perfect person. I showed up for my family every day, 6 o'clock without fail. I was in that house with that family every day, trying to love on them. 7 o'clock every morning, I went to work and I come home. And on September the 21st, I was hit with, I was destroyed, devastated, and appalled that these allegations were made about me by my wife, whom I loved. And I didn't know that there was many other men involved in this until the judge affirmed the order of protection. When that day happened, I was even more utterly destroyed because an affirmation had been made about something that I was in no way guilty of. And so I went through several weeks of very dark spell at that time. And in that time, I had to sit down and learn all the things about what had happened, who was all involved. And so for the following month, it was revealed to me through, looking at everything closer. I wasn't looking close in our relationship. I wasn't paying attention during our relationship. Maybe I was in a fog or something, but when I started paying attention and checking my game cameras at home that I had throughout the woods and in the driveway, and I found out what was what was truly going on.
And
It's
so were
going
there
in.
things, you had mentioned earlier, you had a very close relationship with Scarlett. You treated Scarlett as your own. And ultimately, you ended up questioning whether you were Scarlett's biological father. Were there things that made you question after the fact if you were Scarlett's biological father?
Yes, yes,
Okay,
sir.
and what were those things that you had discovered?
Those things were the text messages that I had found in my phone that my wife had made with my son. The messages I had sent to my wife in reference to her having relations with my two sons, 21 and 22-year-old, and also their friend Nathan, who's about 22 years old. And so when I received text message confirmation from her, when I sent her a message asking her about this, her response was yeah, it happened. And so
Let me
looking.
make sure I'm understanding you. Are you saying that your wife, Ms. Thomas, has confirmed to you that she had sexual relations with your two adult sons and a friend of theirs?
That is correct, sir.
You have proof of that?
I have it in a text message in my phone in my car.
Did she explicitly affirm that she had sexual relations with them, or did she just not deny it, Mr. Thomas?
She did not deny it. She made a response to a message. I said in the message, so you've basically been sleeping around with my sons, and her response was, you've been sleeping around with my band or my sons, and her response was, they were your sons first, or they were your band first. That's the exact context.
But she never made any explicit admission that that was the case, correct?
To me, that's pretty explicit. You know, she was explicitly said, you know, yeah, it just in a different way, you know, she confirmed it. That's one. There are other confirmations as well, and pictures and things that I have.
And so if the court were to award you temporary custody or any form of parenting time with Scarlett today, are you willing to co-parent with Mrs. Thomas?
Yes, sir, I am.
Okay. And what is your position on keeping the two children together as siblings?
That is my goal, that these two girls are raised together and that they know each other throughout the entirety of their life.
Okay. And are you willing to participate in anything this court asks you to do to have visitation with your child right now, with Scarlett right now, to be determined with baby Thomas? Or are you willing to jump through any hoop that this court has? Are you willing to have supervised visits starting out? Are you willing to do anything to have parenting time with your children?
The door is closed currently, sir. I have no children at all. My life was built around my sons, my children. All that was taken from me in this divorce. So to answer your question, yes, I'm willing to do anything.
And why is it that you want custody of your children?
My children are why I get up and go to work every day. They're the reason that I function. My children are the reason that I live, you know, and my reason to live was taken away from me with this, all of my sons, my baby girls, all of that, you know, so I've lost I had to find a new reason to live because my children were taken from me.
And why do you feel that Scarlett is subject to an immediate threat of irreparable harm while in Ms. Thomas's care?
I've learned that Ms. Thomas has so the things that occurred with my boys, they occurred with other people, other men, and it's hard for me to even think about. I keep all this back here, but all of those things were occurring.
Well, specifically, she didn't consult with you about the adoption before Blaze. I'll rephrase.
I'm sorry.
He's getting.
Sustained, don't lead the witness.
I believe you previously testified. Is it true you previously testified that she did not consult you before giving baby Thomas up for adoption?
That is true.
Okay. And are you in fear? Does that create any kind of fear for you due to or with respect to her parenting responsibilities of Scarlett?
Absolute.
Why?
Because that family that she sent our child to live with, we know nothing about those people. They've had our child now for for several months, and we don't know anything about them.
You've never met them?
I've never met them.
You don't know them?
Don't know them, not allowed to contact them, not allowed to inquire who they are, anything about them. Moreover, Ms. Thomas was seeking to aggressively release this child into somebody's care. She was not looking to aggressively research their background, find out who they are.
And you are currently under a temporary support order by this court?
Yes, sir.
Okay, how much a month do you pay to Ms. Thomas?
$1,500 a month.
Okay. Is that just the support order, or does that include everything you pay on her behalf?
So I also currently pay for a 2024 Ford Expedition payment.
How much is that a month?
That payment is over $1,300 a month, less than 14, and the insurance on that vehicle is about probably $300 a month.
And you filed a copy of your income and expense statement with the court yesterday, is that correct?
Yes, sir.
Okay, and I'm going to pass you up, Judge, permission to pass. Now, you are paid a salary by your company, is that correct?
Yes, sir, I am.
Okay, and how much are you paid? Is that a true and accurate reflection of your income and expenses?
Yes, sir, it is.
Okay, so you are operating at a deficit of $701.08, and that is before the spousal support payment is paid, before the car insurance is paid, and before the car payment is paid. Is that correct?
That is correct.
Okay, so are you having to rely on your savings or your business's savings to pay those things? How are you paying, how are you affording to pay for those things?
Sure, it's with my savings account.
Okay, and what was the balance of your savings account at the time this proceeding started?
So my savings account is, it's been around $50,000,
Okay, and what's the balance of it now?
probably 40,000.
And so are you asking the court to reduce the temporary support payment?
I am asking the court to please reduce this support payment. Yes, sir.
And there was a previous hearing that was held. You had different counsel at the time, but is it your claim you did not have notice of that temporary support hearing?
That is correct. I did not know
So
that.
to your understanding, the court didn't hear any testimony from you or any proof from you regarding your ability to pay any type of temporary support?
That's correct.
Okay. And so what are you able to provide any type of temporary support to Ms. Thomas?
Yes, sir. I am able to provide temporary support. I prefer to call it child support, as she has Scarlett, but whatever we want to call it.
And just to be clear, that order classified it as temporary support and child support. So is there an amount that you can afford to pay, Ms. Thomas? And what would that amount be?
You know, honestly, I probably should have thought about that before I answer that question. I know what I make, and I would request that whatever the state guidelines are based on what I make, I would feel comfortable paying that.
No further questions, Judge.
Kirby, you may cross-examine.
Thank you, Your Honor. Morning, Mr. Thomas.
Good morning, sir.
My name's Anthony Kirby. I represent your spouse, Miss Rachel Thomas, okay?
Good to meet you, sir.
Good to meet you. I've got just a few things to question you about. I'm gonna start
Hold on a
on the,
second. Was that made an exhibit, his income and expense statement? Let's make that the next exhibit in order.
for the record, Your Honor, no objection.
Thank you, Mr. Kirby. One of these times I'll get around to asking you about it before.
You're perfectly fine, Your Honor. I was in a trial, 2-day hearing the other day, and a counsel forgot my entire name while they were doing closing arguments, so I'm used to it at this point. Ms. Thomas, I got a couple questions for you, okay? So I'm looking at your income and expense affidavit, and I apologize, I was trying to write down things, but I did not get this down. What is your salary that you get paid?
So I get a paycheck every week of about $800.
Okay. And so extrapolating that out, what is your salary per year?
Here, let me give him back his income and expense statement then, if he's going to be questioned.
Yeah.
Did you say that there was a copy of that in the file?
There's
Let me take this apart again. All right, go ahead, I'm sorry.
And so if you get paid $800, is it fair enough to say that you're paying yourself through the business approximately $41,000 to $42,000 a year?
Yes, sir, that's correct.
Okay. And this is a business you own, right?
It is.
Sole proprietorship?
No, it's an S corp.
S Corp?
Yes, sir.
Are you set up as the sole managing member of the S Corp?
Yes, sir, I am.
Okay, so in terms of who gets to pay who, you get to make that decision top to bottom, right?
Yes,
You don't run anything else past anyone else as far as your income is concerned, correct?
that's correct.
Okay, and I see on your income and expense statement that it says your business pays telephone, car payment, and car insurance. Is that right?
That's correct.
Okay, so you use, like most people do that have a corporation or any sort of business, you use your business profits to be able to pay some of the things for your personal life that you get to use on a daily basis too, right?
Absolutely not.
No?
No.
Who pays for your car?
So my car, so my personal life, I have a motorcycle that I drive. I have other vehicles. This particular car that you're talking about is my work vehicles.
Okay, so do you owe anything on any of your other vehicles?
So I owe money on the vehicle that Rachel drives.
Okay, what about any of the other vehicles that you had? You said you had multiple vehicles in your possession.
That's right. That's what I owe. My motorcycle is paid off and I owe what Rachel is driving.
What other vehicles do you have?
I have a 25 Mustang.
And you bought that right after y'all separated, right?
That's correct.
And you actually paid cash for that?
I did.
Okay, so
No, stop. I did not pay cash for that. That's finance. I'm sorry.
that's finance,
It
but
is
it's paid off
financed.
at this point, right?
No, it's not paid off.
You got money owed on that?
Yes, I do.
Who's paying for that? Your business, right?
I pay for that.
You pay for that
Yes,
through your business?
that's right.
Okay, so that's what I'm getting to, right?
Okay.
You pay for your stuff through your business, right?
This is a work vehicle.
It's your 2025 Mustang for a granite company is a work vehicle.
Absolutely.
You can haul granite on your 2025
I
Mustang?
drive that car to every measurement job, to every meeting, to work and back every day. This
Understood.
car does not sit in my driveway and I don't take it to car meets. I drive it to work. I drive it all around to measure jobs every day.
Understood. And so as far as that car is concerned, you're actually adding on to that vehicle as well, right? You've bought a bunch of parts for it to add on to it, make it faster, make it more cool, right?
No,
No?
I'm not. Let me see. I did put a new muffler on it. Yes,
Okay.
you're right.
Did the business pay for that too?
It did.
Was that necessary for your business, or that's just something you want to put on the
It's
vehicle?
regardless. That's not a question, whether it's necessary for business or not. Whenever I purchase a saw for my granite company, I'm allowed to purchase blades for that saw that increase its productivity.
Understood. Let's talk about your business account then. How
Sure.
much do you have in your business account?
Currently around $100,000.
Okay, so you get to pay through your business account anything that you deem necessary for your life that you think benefits your business, right?
If it's business related, yes,
And you say that you had $100,000 in there right now, right?
that's correct.
Okay. Previously, you had a lot more than that, right?
That's correct.
Okay. I'm gonna pass up a document to you.
Sure.
You recognize this statement, right?
Yeah, the one that was stolen from my vehicle when she stole my truck, yes.
Get to that in a minute, I guess, then. When it comes to this is the business account for the Clarksville Granite Inc., right?
Looks like that's what this is, yes.
And just to make sure, during y'all's relationship, marriage, after the separation, my client has no access to any of these funds, right?
No,
Okay. And at that point in time, you had, this shows $252,101.50 in your business account, right?
that's correct.
Okay. And that was right before y'all's separation statement ending July 31st, 2025.
That's correct.
Okay. Make that the next exhibit, if I may, Your Honor.
Exhibit 3.
So you have $40,000 in your savings right now, personal savings.
Yes, sir.
You, by your testimony here, have a little over $100,000 in your business account.
That's correct.
And at some point within the past year, essentially, you had over $250,000 in your business account, right?
That's correct.
Okay. And you can't afford to pay $1,500 a month?
That's correct. I cannot,
Cannot afford it?
cannot afford it.
Okay. If I do $100,000 divided by 15, that's 66 months at that point, right? Does that sound about right?
Please explain a little closer. I'm trying to follow where you're going with this.
You have $140,000 to your disposal,
Okay,
correct?
that's right.
Okay. And that's not including anything for your checking account. What do you have in your checking account?
Maybe $5,000.
Okay, so we'll discount that for argument of this, okay?
Okay.
So you've got $140,000 at your disposal as we sit here today. If you had no other money go into your business account, you could pay $1,500 for the next 93 months. That seem about right?
No, it does not, because I have business expenses that by far exceed any of that revolve every single week. The $250,000 that you mentioned, there was a employee cost every week of about $9,000, so 9, 18, 24, 36. You know, you're looking at a $40,000 revolving fee on top of granite, materials, gas. $60,000, $70,000 a month is where this, when we were together, that's how it was revolving, you know, and this was an S Corp account. When I lived with her, all of our expenses were also paid from my savings account, not from this business. The entire time that I lived with Miss Thomas, I was given a paycheck from my business. That has not changed.
Pass you up another document as well. You recognize these statements?
Yes, sir, I do.
Okay, these are statements that were being deposited into your business account, correct?
Yes, sir.
On one of them was $45,437.38, right?
That's correct.
One of them was $2,270.61, right?
That's correct.
And one of them was $16,458.23, right?
That's absolutely correct.
Okay, and these aren't all of the things that you're making. These are just showing that you get significant amounts of money paid to your business that you get to continue to deposit into that $100,000 account that you get to use, correct?
Significant amount of money come out of that account. You're only addressing what's going in.
Make that the next collective exhibit, if I may, Your Honor. You and my client have or maybe had a joint account. I don't know if it's still open or not. Is that a correct statement?
It is.
Okay. And did you move a bunch of money out of that account?
Over the past year, I've moved money through that account, in and out of it the entire time. Yes, sir.
Okay. At one point, did you leave 53 cents in that account after a month?
It's very possible. Yes, sir.
This was right before y'all's separation, right?
I'm sure I drained that account once I found out everything that was going on. Yes, absolutely.
So you took it upon yourself. You made a unilateral decision to go ahead and drain that account, right?
How much money was in there when I drained it? Because we only kept like maybe $1,000 in this account revolving at all times.
Well, you essentially, this was the only account in which my client had any access to funds, correct?
Okay.
Is that correct?
So she stole money also.
Well, this isn't my question, sir.
Right.
I'm going to ask the questions. You can answer the
Sure.
questions. Y'all had a joint account, correct?
Yes, we did.
My client had access to the joint account to use funds to purchase things throughout the day, correct?
That's correct.
Okay. She did not have access to your savings account that has $40,000 in it, correct?
She had her own bank account also,
did.
apart from this account also.
She did not have access to the $5,000 in your checking account, correct?
But that account is this account.
And she
right?
didn't have so now you've built this back up to 5,000 is what you're saying.
That's what I'm saying, yes.
And she didn't have access to the $252,000 that was in your business account, right?
Did she have access to it? Let me think about that answer for a moment, please.
I think you've already said that she didn't.
No, she's had well, here's something I forgot, okay? I have noticed that maybe she didn't have access to this, but she has, she gained access to it several times, and we'll get into that later.
Okay. As far as this, though, it's your testimony that this typically had $1,000 to $2,000 in it at that point,
Which account are you referring to?
the one that I just passed up for you.
Yes, sir.
Okay.
That's about right.
And now it's at about $5,000, correct? Okay.
That's correct.
And my client doesn't have access to that account as we sit here today. Is that a fair enough statement?
That's correct.
Okay, because you removed her from that account, right?
Yeah, that's right.
Okay. And when you find out that there was things going on based on your statements and your testimony here today, you drained this account and left with 53 cents in that account, correct?
That's correct.
Okay, made that the next exhibit if I may, Your Honor. My client was essentially solely reliant on you for income during y'all's marriage and relationship, right?
That is not true.
No? You were the primary breadwinner for the home. That's got to be true, right?
I was with her for 1 year. She had child support from 2 other men.
Okay, so she had child support from 2 other men at that point for children that she still has in her care and custody, right?
That's correct. That
Okay.
she never used. She stored it away in a secret account somewhere nobody knew about, nobody cared.
Okay. And so in terms of money that was coming into the home, you were the one providing money coming into the home for the 2 of you, right?
For the year and few months that we were together, we knew each other, yes, sir.
Okay. And you want the court to now say that you shouldn't have to pay her the $1,500, you shouldn't have to pay for her insurance, you shouldn't have to pay for her vehicle. You should just calculate out whatever's on the child support worksheet based on the $800 a month you've decided to give yourself unilaterally through your business, right?
That's exactly right, yes, sir.
Okay.
Not $800 a month.
$800 a week, I apologize, that
That's
was my
right.
bad, Your Honor.
Yes, sir.
Thank you. $800 a week,
Yes, sir.
okay. Another point of this, you really just don't like my client, right?
I love her and I have forgiven her. There's no don't like about it. I was in love with her and my pastor has taught me to forgive her and I still love her
When was that forgiveness taking place?
over the past several months.
Okay, so when you paid your $1,500 for support on July 1st and you put into the memo line that you were paying her for telling lies and stealing, was that forgiveness?
I don't know what that was.
You did that though, right?
That's what she did, so that's what it was for.
But that's forgiveness in your book, right?
I have forgiven her.
Okay. And in terms of the aspect of this hearing that happened previously, right? Let's go through that for just a moment. You were duly represented at that point. You had counsel.
What hearing are we referring to, sir?
When the current support was ordered, you had counsel at that point, correct?
At that hearing, my counsel had submitted his documentation to be removed as counsel. So that's when her counsel stepped in and had this support hearing made. I was not aware that I needed to be present at that. I was not told I needed to go. I knew my attorney was removing himself. I was not prepared to argue that, so I didn't go to that hearing because of that reason.
And you just decided not to go, but you knew that the motion was on the docket, right?
I knew my attorney was removing himself from my case.
And you knew that the motion for support was on the docket
No,
as well?
absolutely not.
Well, you just said that you weren't
I
prepared
did
to.
not know that hearing was that subject matter was being heard. All I knew, as God is my witness, is that my attorney was removing himself from my case.
Let me. And if your attorney came into this court and represented that he had spoken to you and informed you of that motion, he would be lying to the court?
Absolutely, sir.
As an officer of the court, you're
No,
saying
no,
that
he
he's
told me
lying to
about
the court?
the motion to remove him from my case. He did, and in fact, we never spoke about that. I got an email that said that on this date, I read the motion. It said that he was removing himself on this date. And in my mind, I thought, okay, he's removing himself from the case. I'm not arguing that. It doesn't say here, Michael, you need to be here on this date. I just seen I never even received a subpoena for the date. I just seen the motion is what he emailed me. So it didn't click in my little simple mind that I needed to be in court that day. I wasn't arguing it. You know, I knew I had to find another attorney is what my little mind thought.
Understood. Let's go with your other motion then for just a moment, okay? As far as this emergency motion that you filed. First off, you had told multiple people that these children weren't your children, right?
I've never told anybody that. I said there was a question after I found out about some things.
Some things that you inferred through my client's response based on your testimony. There was never any sort of admittance to anything on that side of things, correct?
She has admitted to it. My sons have admitted to it, yes.
Okay, your sons aren't here today, right?
That's correct.
And you haven't presented any sort of actual proof that she's admitted to it, right?
I was not advised that that was something I needed to prepare today.
So that was something, you had issues with your previous counsel, now you've got issues with this counsel, not advising you of certain things.
I
That's
have
your
no
testimony?
issues with my counsel.
Okay.
We were here to address something different today. We weren't here to address those ugly things. We're here to try to help me gain a little time with my children.
And that's what you're asking for at this point, right, is a little time with your children?
I'm asking for full custody of my children.
Well, that's far different than a little time with your child. So
Well,
which one is it?
Pardon me for misspeaking. It's full custody is what I'm asking for. And to be honest, the best word is anything,
Well, that's again also far different than full custody.
right? Because right now I have nothing, sir.
Okay. And you've got nothing because there was an order of protection that was taken out, right?
Yes, sir.
And you were served with that order of protection.
Yes, sir.
And you didn't show up to that order of protection, did you?
I'm sorry. I believe I attended all court dates.
Did you?
Yes.
Okay. And there was a
believe I did.
hearing after that.
I'm not aware of a hearing that I missed, sir.
But the order of protection was put in place, right?
Yes, it was.
Okay, and there was an agreed order at some point put in through this court saying that my client could go to an undisclosed location based on the domestic violence that had occurred within y'all's marriage, right?
Based on the alleged domestic violence, yes, sir.
Okay. And you were arrested for domestic violence, correct?
I think they arrested me for something else. It was violation of the order is what I was arrested. I was never arrested for domestic violence.
You've been arrested for aggravated assault many times in your past, though, right?
Not that I recall, sir.
You've been found guilty of aggravated assault as a felony previously, right?
Not that I recall, sir. I don't remember that.
Hold on just a second. I'm sorry. Well, he can only be cross-examined about what he may have been convicted of, not what he's been charged with, because that's the rule of evidence is that you can cross-examine a witness regarding a prior conviction of a felony if that, or a misdemeanor involving moral turpitude. So sustain the objection as to the form of the question at this point.
I'll rephrase at this point. You were previously convicted and put on probation in Georgia, right?
13 years ago.
Okay.
And if it's over 10 years, it's not admissible anyway.
I'll move past. You were previously, do you still have a pending criminal charge for aggravated assault in, I believe it was South Carolina?
Absolutely not.
You were arrested on that though, right? When was that taken care of?
So that was taken care of 2 months ago, and the district attorney in that case called me.
I'm not going to ask you what the district attorney says. You can't testify to what anyone else says. Do you have anything here with you today that says that that was dismissed or taken care of in some way?
No.
Okay. And as far as your emergency motion that you filed.
That was over 10 years, by the way. Also.
you don't have anything in terms of, the charge wasn't over 10 years ago, you just got arrested on it recently.
Yes, it
but
was. It was over 10 years, sir.
It just got resolved here recently, though, right?
Right. It was
By your
thrown-
testimony?
It was thrown out.
Okay. As far as the aspect of what you're asking for here, your motion deals entirely with who we've been referring to as baby girl Thomas and this adoption aspect of things, correct?
Can you repeat the question?
Your motion deals entirely with who we've been calling baby girl Thomas and the adoption aspects of
What
things,
motion
correct?
are you referring to? Because there's many of them here.
Sustained.
You filed a motion for emergency custody, emergency return of the minor children, right?
Yes, I believe
And that
we
was
have.
based on the fact that you found out that there's an adoption that's pending in Colorado as it relates to baby girl Thomas, correct?
So I filed the motion for custody of that child when I was presented with legal documentation that said she had signed away her rights to that child, and this new family was asking me to sign away my rights. It was at that moment that I found out, because I've been in the dark, that my child was in another state. It was at that moment that I learned I have to take legal action right now. So to answer your question, yes, sir, that's whenever I filed the motion.
Okay. And then as far as Scarlett is concerned, you have absolutely no claim that Scarlett is being mistreated in any way, correct?
I have no claim because I've had no contact. I don't know. I do know the life that was lived when she was here. And
Okay. And just to be clear, you haven't presented anything as far as photographs or videos or text messages to corroborate anything that you've testified to about these alleged affairs that seem to be the brunt of your concern with mother, right? None of that's been introduced today.
it has not, no, sir.
Okay. And so as it relates to Scarlett, what's Scarlett's date of birth?
Scarlett?
Yes.
Scarlett was born on March 17th, 2024.
2024?
2025, I'm sorry.
Okay. And so at this point, y'all have been separated since September of 2025, right?
Yes,
And so this child, it's fair to say, doesn't know you. Is that a fair enough statement?
that's not fair at all. I spent every day with that baby for the first 6.5, 7 months of her life. And I don't know about you, but for 7 months that you spend with somebody, would you say
You
in
can't
5
ask
months?
him questions, Mr.
Sorry, sir.
Thomas, you just answer his, please.
Okay, sorry, I apologize.
During that period of time where the child was in your home, did you have issues of anger?
No, sir.
You didn't yell, you didn't cuss at other people in the home or other children in the home?
I'm sure at times I raised my voice, yes, sir.
You raised your voice at times, right?
Yes, sir.
Did you ever go so far that you ripped apart an oven so that it was not useful?
I don't recall ripping apart an oven that was, no, I know that I did not. So to answer your question, no.
I'm going to play a video, if I may, Your Honor, and a best way to do this that I know of would be to play it and stand over here. Or
You can play it through the network if you got to plug it in. We've got bailiffs here who are fairly adept at that. We have a USB cord there on the.
I can log into the video and share my screen.
Whatever you want to do. If you're going to show him, I assume you want me to see it at some point too.
Yes.
Then you show him and then you can show me, whatever you want to do. I don't care. We're approaching the noon hour and we'll be adjourning for lunch, or recessing for lunch. So what I would say is let's get as much ground covered as we can, so.
And yes, Your Honor, and I've got a final hearing in Montgomery County that's been pushed to 1 o'clock at this point, so I've got that issue as well. So let me try to play this for him, and then I'll play it for you, because that'll be the quickest way of doing it. It's a short video. I have, for the record, I have shown this video to opposing counsel. I approached to.
Well, let me ask you a question. If you are supposed to be at a final hearing at 1 o'clock, exactly, we're not going to be finished with this hearing at that point.
I would hope we wouldn't be, I'm almost done with this. I guess we're not going to be, but we're calling other witnesses.
Well, I was expecting that it would be more than just Mr. Thomas. All right, go forward with this, we'll deal with that.
I would make an objection to this video. I don't think my client's present in the video.
What is the video of
The
Mr.?
video that has a foundation has been filed.
What is the video of Mr. Kirby?
Video is of Mr. Thomas, and you can clearly see, not see, but you can clearly hear his voice as far as what is being said through that. It is a early morning in which he is, I'm going to say, belligerent, talking to other children within the home. This would have been after the birth of the Scarlett. The video was taken by my client, but I believe that he can easily testify and identify his own voice.
Join the video and he'll be asked if whether or not he can authenticate it. If he cannot authenticate it, then it cannot be introduced.
I'll play it through my client at that point. May I stand over here? I'll stop it there for. Ms. Thomas, did you hear that video? The part that played?
I heard the video, yes, sir.
Okay. Is that your voice in the background?
That could be my son. We sound exactly alike.
It could be your son?
Yes, sir. His name
Okay.
is Dalton Thomas.
Okay. So you think that it could be your son? Do you recall this exchange in any way?
I do not.
You don't recall the exchange in
No,
any
sir.
way? Okay. I'll just play it through my client. As we sit here today, you have no proof saying that Scarlett is not being well taken care of in mother's home, correct?
That's correct.
Okay, you have no proof saying that she's not being able to provide for that child in terms of food and clothing and everything else, correct?
Correct.
And you haven't seen your child in a year, correct?
That's correct.
And are you asking this court to simply take that child away from mother at this time and place that child with you moving forward?
Yes, sir.
And you think that's in the child's best interest?
Yes, sir, I do.
Even though that child hasn't been with you for over a year and all of the things that have been going on here?
I think that is in the child's best interest. Yes, sir.
Okay, even though you agreed previously that she'd be able to relocate knowing she was pregnant at that point, right?
That's correct.
Okay. Nothing further right now, Your Honor.
I have a couple of questions. You said that Mr. Kirby just asked you if you agreed to her relocating. I don't know that there's an order in the file here. I haven't been able to find it. Where did you agree to her relocating?
I was not exactly informed that I recall, sir, of where she was going. Just out of state is how it was labeled in the paperwork that was presented to me.
All right. When you and she married, if I understand correctly, you were married less than a year at the time she separated from you or she left. Is that correct?
Yes, sir.
During that time, did she work outside the home at all?
She never worked. No, sir.
All right. How did you and she meet?
She came into my business looking for countertops.
All right. And she lived here in this area at that time?
Yes, sir. She owned a house in Clarksville.
And when she came into your business looking for countertops, you and she met, obviously, and then you started dating, and then you married, and you were together for a year before you separated, correct?
Yes, sir.
And it's been a year since your separation?
Yes, sir.
Roughly.
September we separated.
September, it'll be a year this September?
Yes, sir.
All right. Now, are you living alone?
Yes, sir.
Okay. And we're talking about Scarlett. Scarlett is a child of how old? 1 year old?
Yes, sir.
So I have some experience with 1 year old children and grandchildren. Exactly how are you proposing to, I see the pictures of your home and it looks fine. How are you prepared to care for Scarlett if she were to come and stay with you?
Sure. I have a friend who is here to testify today that would testify to her ability to help me care for Scarlett.
This is a female friend that you have?
Yes, sir.
And is that somebody you're involved with as a person,
No,
more than
sir.
a friend?
We are not more than friends, no,
All
sir.
right. And so you have someone lined up that would be able to help you if Scarlett were to come here?
Yes, sir, and have actually, many, I have a church family who would also be more than willing to help me take care of Scarlett. Roberta is here, her name is Roberta, she's here today to testify to her willingness to help me, and, yes, sir.
And how many children does Mrs. Thomas have?
Currently, she has Connor, which is her 4-year-old. She has Dominic, her 13 to 14-year-old. She has Briah, her 15, about to be 16-year-old. So she has 3, and she has Scarlett, our child, together. So currently, she has 4 children living with her.
The youngest child that we're talking about that's in adoption, or has been put up for adoption by Ms. Thomas, that would be her 5th child?
Yes, sir.
Right. And how many children do you have?
I have 5 children that have grown up and moved out of the home, and they're out in the world doing their thing these days.
2 of those were your sons that work with you?
Yes, sir.
And those are the 2 sons that you're basically accusing of having a sexual relationship with your wife?
Yes, sir.
And how old are they?
The boys are 21 and 22 now, I think.
And I don't want you to tell me what it is, but you're saying you have some proof that that is in fact what has occurred?
Yes, sir. I have more than some proof. Yes, sir.
All right. Any questions based on what I've asked you? Thank you. Step down. Step down. Gentlemen, Mr. Kirby, you have this final hearing. Who is that in front of?
This was set first, and I informed Chancellor Dean and opposing counsel there that I needed to come here to deal with this situation. But that was set on Chancellor Dean's docket for today because that is it's a final evidentiary hearing that's dealing with where is a child going to go to school starting up essentially next week, which is why he set it on that docket for then. Mr. Daniel Bryant's been nice enough to accommodate me this morning. He's the opposing counsel on that.
We'd like to be heard today. Obviously, Judge, we've got witnesses here. Our last 3 witnesses, if the court needs to hear from them, are purely character witnesses, a pastor, support system, friends that have known Mr. Thomas for 7 years. And I'm not sure if the court needs that proof today, but they're here to say what kind of person he is. They've observed him at work. They've observed him. You know, the defendant in this case has alleged that Mr. Thomas is on drugs, has alleged Mr. Thomas is abusive, and he's got a slew of character witnesses here today to testify. They've known him for a long time and have never observed anything like that. They've never observed him lose his temper at work. They've never observed him be on drugs. They've observed him to be an upstanding member of the community. I'm not sure if the court needs to hear from them. Mr. Kirby plans to call his client. I would have a pretty brief, I think.
I think
we're asking to go forward today.
I think it would
What
be.
do you have tomorrow? We don't have anything now. What do you have tomorrow morning?
Let me grab my calendar. I have 1 motion that I can have covered, and the rest are consults that I'll move.
I could be back tomorrow morning.
9 o'clock tomorrow morning, we'll resume this. I want to make sure everybody understands. I have to leave to go to a dental appointment in Franklin. I've got a crown that keeps coming off. And unless you want to have me proceed with a snaggletooth look, then I got to leave here a little before 2. So I would think that tomorrow morning in the 3 or 4 hours, we could conclude this matter. Both of you need to address the issue. Mr. Thomas, regardless of whether your client thinks he's a good husband or a bad husband or whatever, I understand your arguments about the alleged violence. He has a right to see his daughter, Scarlett, and that's all we're dealing with. So I want to be able to address under what circumstances each of you proposes that happen. As far as the immediate return of the child to the state of Tennessee, That's equivalent to, unless she moves back here, it's equivalent to granting him temporary custody, and that's a kind of a tall order considering where we are with everything. But I want to know what both of you propose for at least some sort of temporary visitation with him. He has the right to see his daughter, but it has been a year or so since he's seen this child, and the child of that age is going to be some adjustment that's going to be required. Normally, if they were living here together, I would be putting down an order of a graduated type of visitation. That doesn't appear to me not necessarily to be the case. In addition to that, we've got to work around this order of protection and whatever. So we're going to be looking at exchanges of the child, assuming that there is a visitation, exchanges of the child through third-party mediation or mediaries, so that there's no direct contact. The last thing I want is for Mr. Thomas to be in violation of his order of protection. When does that expire?
It's on appeal. So
Okay.
the previous council had reserved it for final hearing in this court. So
I think technically, and this is not what I'm necessarily suggesting, but I do think technically the court could amend the order of protection at this time because the fact that it is, I don't know that it's, since it's on appeal, I'm not really sure.
If it's been more than a year since it was issued, even if it was on appeal, it's expired. I'll deal with it.
No, it's not been more than a year.
All right, then here's what I'm suggesting. We'll start at 9 o'clock. Both of you just keep in mind what my problem is. I want him to see this child. I want him to have contact with this child, and I want to protect the child from being traumatized by being around somebody that she may not be familiar with. But we're got to move in that direction, because unless there's some proof that he is unfit at all to have any custody or visitation with the child, he's going to get to see this child. So, and it may be graduated moving forward. One option is we just have the child brought back here and stay with him for a month, and then go back to the mom and stay for a month or a week at a time, something like that. I can then say that for the purposes of giving you an understanding that I take seriously his right to see the child, even if there are these issues that occur between them.
thank you, Judge.
So be prepared to address that tomorrow.
Understood.
All right, we'll deal with the economic issues as well, and obviously I'll need to hear from her regarding her economic situation as well. So the court is going to be considering the fact that the obligation that Mr. Thomas has is for the support of his child, and that will be based on the child support guidelines. His support for her is based on whether or not there's an alimony or spousal support issue. That, as you all know, goes to the factors that are set forth in the statute, which include the length of the marriage that the parties have. We got a 1-year marriage, so keep that in mind when we talk about tomorrow. All right, I will see you all at 9 o'clock. She will need a Zoom link. Let me look and see if I can just give one right quick. That will work. I need to change it. See, here, I was supposed to be in Cheatham County, so my Zoom link was for Cheatham County. That's why it's showing up as Cheatham County. Tomorrow, I was supposed to hear a Humphreys County case, but we'll do that with the same Zoom link. Give them that Zoom link. So.
We're still coming here, though, correct?
You are coming here.
Okay, I just want to make sure I didn't drive to Humphreys
No,
County when I would
no.
need to be in Dickson.
All right, hold on. I'm going to change, that's for 30, so I'm going to edit that so that it'll show what it's actually supposed to be.
And I apologize about the scheduling of today, Your Honor. This got put on my calendar.
You tell Chancellor Dean that I am deferring to him only because I like him, and I like him, and that he's a fan of our YouTube channel, so if he might learn something, so.
I will make sure to start off my opening that way because maybe it'll get me some brownie points.
Sounds good to me. Thank you.
Thank you, Judge. Thank you very much, Your Honor. Ms. Thomas, I've got the other hearing, but I will call you when I get done with that because I'm going to go straight into that hearing, okay?
Okay.
Thank you. Thank you, Your Honor.
All right.
I'll still try to remember just in case it falls out. I always love being organized at the beginning of a hearing and then completely destroying a file in about 2.5 seconds as you get stuff out. Yeah. And if the court wants to send me that Zoom link, which I think is what Ms. Turner did this morning, I can forward that to my client. She should have my email.
I'll send it.
Okay.